Hi, I'm Gene Trowbridge, and I'm here with my law partner, Lisa Taylor. And today we're in beautiful downtown Tampa, Florida, getting ready to do a CCIM conference tomorrow. We thought we'd take some time to share with you our thoughts on the new rule that was just passed regarding the Jobs Act and the ability to advertise for investors when you do a Regulation 506C offering. Kim is going to tell us about the new rule, and then I'll come back and talk to you about what we think is happening in the future. Kim?
Great, thanks Gene. Well, before we start talking about the new rule, let's just kind of lay the groundwork on what is the old rule. Well, the old rule is, as we affectionately know, Regulation D, Rule 506, is actually going to have a new moniker, and it's going to be a 506B offering. That 506B offering is the same thing that we've been doing for our clients in the past, that doesn't allow any advertising or solicitation. It allows you to bring in accredited investors, but it also allows you to bring in up to 35 sophisticated investors. There's no limit on the number, the amount of money that you can raise, and you don't have to have a PPM if all of the investors are accredited, but if even one of them is not, then you do have to have a PPM. So that rule, that 506B, is going to stay in effect, and a lot of our clients are using that because they are using sophisticated investors for that deal. So that business is the same, but the new rule is called a Regulation D, Rule 506C offering. And that particular rule will allow you to advertise to anyone, but you can only sell to accredited investors. You're going to have to take some additional steps on the 506C offering to be reasonably assured that your investors are accredited. And the SEC has issued some non-exclusive guidelines on how you can go about doing that, but the burden is going to shift to the issuer to make sure that they've taken those steps. Some of those steps include things like looking at the last 2 years' tax returns, pay stubs, 1099s, or financial statements that have been reviewed by a CPA or attorney or some third party. So those are some things that you'd need to do. In addition, there are some provisions that apply seemingly to both of the 506B and 506C offerings, and those pertain to who can make those offerings. The officers, directors, managers, general partners, anybody who's taking on a management role in the issuer, as well as any investor that has a 20% interest in the company issuing the securities, would be prohibited from actually participating if they had been in trouble in the past for certain financial crimes or had received some orders from some regulatory agencies pertaining to some financial wrongdoing or from the Postal Service. So I'll turn the next part of this over to Gene.
So Kim, what you were just talking about is referred to as the bad boy provision. Do they ever have any bad lady provisions too? Should they have that? Well, as Kim and I were talking about this new rule before we started shooting this, one of the things that we both agreed on is the biggest change we see is the burden shifting from the investor to the issuer when it comes time to be reasonably assured that the investor who's investing with you is accredited. Right now, Kim, on our subscription agreements, we just ask the investor to check a box that they're accredited. That's and right. That'll stay the same in Rule 506B. It's all confusing. But if we go to 506C, the burden is going to shift to the issuer to verify, to take steps to be reasonably assured. That's the big set of words, reasonably assured, that the investor is accredited. So with the freedom of advertising comes some more restrictions, and it makes some sense. And that follows right into the fact that the same day that the SEC approved the rule establishing the 506C offering where you can do advertising, they proposed an amendment And the amendment is something we need to pay attention to. You know, I think we need to make sure that everyone understands that this Rule 506C won't be effective for 60 days after it's published in the Federal Register. So as we're speaking here today, you can't do any advertising. But once that rule has been published for 60 days, then it works and we can do our advertising. But we have to look out for what might come in the amendment. And since we really don't know if the amendment would even pass, we'll just highlight some of the things we're worried about. Number one, the Form D process will be more complicated for our issuers. There'll be more Form Ds to file. There'll be expanded information about the offering that'll have to be filed. If you don't file a Form D, you'll be disqualified from doing a Regulation D offering for the next year. And in the marketing, of course, the regulators are concerned that if you're advertising to investors, what you're saying is the truth. So in the marketing, they would like to have you put in some disclaimers and some legends that they're going to prescribe for you to put in your offerings, and that'll make it a little different. And then they would also like to see you submit your marketing materials in advance of the offering to the SEC. Now, none of those things we just talked about in the amendment are passed, and maybe none of them will be passed, but it just kind of goes along with the thought all along since this Job Act has been passed that while Congress liked the idea of capital formation and advancing capital formation by allowing advertising, the regulators were worried about certain sponsors and issuers taking advantage of advertising, and they're interested in protecting the public. And so I think we could, don't you think we could probably see some more teeth put into this in the next 4 or 5 months?
Yeah, it's possible. And so, you know, there's a little bit of a question of what happens if the new rules that were just approved take effect before these amendments, and you know what happens in the interim. So we'll just have to wait and see how that all falls out. But what do we think this means for our clients right now, Jean? Do we think that there's going to be a flood of people wanting to do these 506C offerings?
Kim and I don't agree on this absolutely, and that's what's fun about it. But I think many of our clients use sophisticated investors, Kim. They come from people with their money in their IRA accounts and their 401ks, and they're just not accredited. That Dodd-Frank rule, taking away your personal residence from your net worth requirements of being accredited, really cut down the number of accredited investors there are. And so I think many of our investors who are doing specific property packages where they're raising $1 million, $1.5 million, probably won't take advantage of the advertising. But what do you think?
Well, I think you're right about that. With the specified offerings, I think that the 506C burdens could become a little bit too cumbersome for people that are on a short timeline, and it's going to be a little bit more costly for us to do the legal work for you because there are going to be some additional hoops that everybody has to jump through. So it might not be something that's really going to affect our clients doing the specified offerings where they already have a property under contract. But if we have some clients that want to go out and start doing some blind pool offerings where they want to raise some amount of money and then go out and buy properties that they haven't yet identified, they aren't really under the same kind of a time constraint, and it might make more sense for them to do that. They could be raising more money, which would justify the additional legal costs and the extra time period that it would take to get that offering ready for them to use.
And don't you think, Kim, that we probably will be given the opportunity to write offerings for sponsors who want to go after institutional investors where the minimum investment might be $1 million or $5 million? That would be a perfect place for using this new advertising capability, and I think that's going to be exciting, and that's really going to expand our business. My last thought before we say goodbye is nothing has changed yet. Don't advertise your current offerings. If you're going to start an offering next week, be prepared to do it without advertising. We need to wait till this thing gets published in the Federal Register, and then we need to wait another 60 days until it's effective. So just stay the course, and we'll let you know when you can take advantage of the new rule 506C. Did I get that right?
That's right. That's
Good.
right. And if you have any questions, you want to know more or talk to Jean or I, please visit our website at syndicationlawyers.com or give Jean a call at
949-855-8399.
or you can give me a call at 904-584-4055. Thank you.
Yeah, thank you, Kim.
Thanks, Jean.